we have the topic which we are going to discuss is about crime against women and children. Before introducing my learned speaker, I would like to throw a light on the topic of today's workshop, crime against women and children. In the ancient India, women held a high place of respect in the society, as mentioned in the Veda and other scriptures. Volumes can be written about the status of our women and their heroic deeds from the Vedic period to the modern times.
मैडम मैडम राम मैम आपका आपका थोड़ा कैमरा देखिए, कैमरा नहीं आ रही है।
नहीं आ रहा?
हाँ, आप ऑडियो वीडियो को ऑन कीजिए।
वीडियो ऑन अभी आ रहा है?
अभी ब्लैंक दिख रहा है, ब्लैंक। हाँ, यस। गो स्टार्ट में, स्टार्ट। ठीक है, आप ठीक है।
In the ancient India, women had a high place of respect in the society, as mentioned in Rig Veda and other scriptures. Volumes can be written about the status of our women and their heroic deeds from the Vedic period to the modern times. But later on, because of social, political, and economic changes, women lost their status and were relegated to the background. Many evil customs and traditions stepped in, which enslaved the women and carried them to the boundaries of the house. The official statistics shows a declining sex ratio, health status, literacy rate, work participation, political participation among women. While on the other hand, the spread of social evils like dowry death, child marriage, domestic violence, rape, sexual harassment, exploitation, molestation, kidnapping, cruelty are few of the harassments which are being rampant in different parts of India. United Nations defined violence against women in 1993, stating that it is an act of gender-based violence that results in or is likely to result in physical, sexual, or psychological harm or suffering to women. Meaning of crime against women is direct or indirect physical or mental cruelty to women. Crimes which are directed specifically against women and in which only women are the victims are characterized as crime against women. Violence is also known as abuse and includes any sort of physical aggression or misbehavior. When violence is committed at home, it becomes a part of domestic violence. The Ministry of recognizes that incidents of crime against women cannot be controlled unless the mindset of people in general are made to change. There are many reasons behind increasing crimes against women, such as unequal economic, social, political status of women, patriarchal mindset, etc. Police and public order are state subjects under 7th schedule of the Constitution. The responsibility towards maintenance of law and order and protection of life and property is primarily of the state government. The Ministry of Women and Child Development is administering various laws relating to women, such as the Protection of Women from Domestic Violence Act 2005, the Dowry Prohibition Act 1961, the Indecent Representation of Women Act 1986, the Sexual Harassment at Workplace Act Prevention and Prohibition and Redressal Act 2013, the Prohibition of Child Marriage Act 2006. Apart from all this, there are other laws which are also working in India regarding the children. India is a signatory to United Nations Convention on Right of Child (UNCRC) since 1992. In adherence to this, we have National Policy for Children 2013, the Protection of Children from Sexual Offences Act, that is POCSO Act 2012. It has also Juvenile Justice Care and Protection Act of 2015. And then we have the Commission for Protection of Child Rights, CPCR Act of 2005. Along with this, there are several constitutional provisions regarding women and children, that is Article 14, 15, 16, which talks about prohibition of discrimination, gender equality, gender justice. Not only this, there are several legal provisions which are also there for women that are basically Maternity Benefit Act of 1961, the Dowry Prohibition Act, Equal Remuneration Act of 1976, Child Marriage Restraint Act. IPC has several sections like Section 354, outraging the modesty of women, Section 509. And then we have Medical Termination of Pregnancy Act 1971, Criminal Law Amendments Act. So there are a plethora of laws which are relevant for the women and children in India. Talking about international initiatives in which India has participated is about the Universal Declaration of Human Rights, which has affirmed the principle of inadmissibility of any kind of discrimination and proclaimed that all human beings are born free and equal in dignity and right. General Assembly adopted Declaration on Elimination of Discrimination Against Women, that is called as CEDAW, in 1967. That was a convention on elimination of all forms of discrimination against women. There were 3 conferences in Copenhagen and Nairobi. The 4th conference was in Beijing in 1995. So now we have come to know that there are so many international initiatives along with the national initiatives which are there to curb the gender violence, and the initiative is also taken by the National Commission for Women, which was set up in 1992, then 73rd Constitutional Amendment with Reservation for Women, National Plan of Action for Girl Child of 1991, National Policy for the Empowerment of Women in 2001. With this background, now may I like to call upon our speaker, who is the next speaker from Odisha, and I heartily welcome you, sir, of this session. I would like to give a brief biodata about sir. He has teaching experience of about 34 years, administrative experience of about 22 years. He has 12 years of guiding PhD scholars, and he has 5 PhD scholars awarded PhD under him. 12 articles have been published by sir in UGC listed journals, 20 articles in reviewed refereed journals, and he has 4 books which he has authored by himself and 6 chapters published in book. The list of papers presented in international conference is 11, and he has presented 48 papers in the national conference. Invited lectures attended are 12, and membership of professional academic bodies is 10. Currently, Professor Das is working as a principal in Vikas Law School, Bardar. So, I heartily welcome Vikram Das sir to this online workshop, and sir, you please kindly continue with your speech.
Thank you, Priyaji. Thank you, Routiya.
एक मिनट सर, एक मिनट सर, एक मिनट.
Kestrilaal Mormadi,
Vikas Das sir.
Vice Chancellor, Pandit Ravishankar. I audible, sir?
एक मिनट. थोड़ा सा मैं राजू चौधरी सर को इनवाइट करना चाह रहा हूं मैं कि 2 मिनट जो है आप भी इस वर्कशॉप के बारे में जो है थोड़ा सा संबोधित करेंगे. राजू चौधरी सर who is our head of the department SOS in law.
Thank you, Routiya ji. बहुत धन्यवाद. Thank you. Sir, namaskar. On behalf of each and every unit of School of Studies in Law, Pandit Ravishankar University, I express my sincere thanks to, as well as I welcome Dr. Vikram Das sir, who kindly consented to act as a resource person. Sir, we are highly elevated with your kind presence, as you have spared your valuable time for your busy schedule. School of Studies in Law, Pandit Ravishankar University always try to conduct the programs which are beneficial to the students, and we are organizing this program under the leadership of our Honorable Vice Chancellor, Professor Kestrilaal Mormadi, and under the supervision of Dr. Priya Rao and Dr. Routiya. Now, all to Routiya ji. Thank you. Again, I express my sincere thanks. Thank you.
Start, sir. Start.
Okay. At first, I must extend my heartfelt gratitude to the Pandit Ravishankar Shukla University, Honorable Patron Professor Kestrilaal Mormadi, Honorable Vice Chancellor of the University, Professor Girish Kumar Pandey ji, Registrar of the University, Professor Rajiv Chaudhary sir, Dr. Priyamam, Dr. Routiya ji, I am extremely happy because you have given me an opportunity to speak few words on this occasion of 5 days webinar and workshop. I extend my heartfelt thanks to my co-resource person, Professor Jaisankar Prasad ji, Central University Allahabad, Advocate Rajesh Singh ji, Professor Vijayananda Behra ji, Professor Surendra Kumar ji. It is a very much happiest occasion because on this pandemic time we could able to assemble and discuss so many things of national interest. And today I am being chosen to talk on the subject that is crime against women and children. Really, Ravi Shankar University is a place for me. It is a very friendly place. Always it is inviting intellectuals of high eminence, of national and international importance. I know both Riya ji and Rautiya ji, they are making an effort along with the steering ship of Rajiv Chaudhary sir, because these are the time we must congregate, discuss so many topics and create world leaders of future India. I must address my gratitude to all the participants. Those are the future leader of the country and the world. You will steer the nation on the backdrop of our Indian Constitution. Before turning to the topic, we must know the historical importance of the subject, that is women and their position. It is said, a woman brought you into this world, so you do not have any right to disrespect anyone. So with this word, we must see the importance of the women and the rights of the children. Any act of crime caused against them, ultimately we are ruining the future of this human civilization. Crime against women and children is a great public concern, not only for India but for the world. Although crime is a concern for everyone, but women and children are more susceptible to the victimization. Often their rights are overlooked and they are exposed to the criminality owing to their tender age of the children and the weak position of the woman. She is innocent, lovely, affectionate, as a mother, as a sister, as a wife. So in this context, she is always duped by the cruel persons. In a customary societies, certain types of crimes are socially considered acceptable. Crime against women and children has tremendous impact so far as their public well-being, health, safety, productivity, and law enforcement. Crime against women is an extreme manifestation of the gender inequality, gender-based discrimination. Crime against women and children have been witnessed from the generation to generation. Violence against women and children encompasses physical, sexual, mental, and vulnerable countries of the world like India, where large amounts of crimes are committed against the women and children. Female infanticide is another example of crime against women. In order to stop such crime, there are several international conventions has been called on, that is being signed, action plan prepared, and execution has been made. Similarly, we the people of India have taken a vow to protect the interests of the women and children, and the apex court has traveled 1 miles ahead of this. So in this context, that we'll discuss the position of women and children of our past. That Maharshi Manu declared, Jatra Najyanti Pujyanti Ramyanti Tatra Devata. Where women are being respected or worshipped, there you will find God will incarnate. So Manu further stated, Pita Rakhanti Kaumare Bhatra Rakhati Jovane Rakhati Sthavire Putra No Stri Swatantra Bhavanti. So these are the two stotra of Manu indicate the position of women in our society. That father is protecting when the woman is a child, husband is protecting when she is in the youth, children are protected, children protected the parents at the old age. So women never get swatantrata or never get independence. In the early societies, men were very much playing that is active role and women are playing a very passive role. However, many scripts written and argued that the women were honored and secured within the house. Our two great epics of Ramayana and Mahabharata placed women with a high esteem and providing a high status in the religious freedom pursuit. No rituals are complete without participation of women. Whenever any ceremonies are being made in the house, ultimately we need that women must have equal participation. The importance of women was increasingly felt as they are treated equally with men. They are allowed to take part in all religious discourses and ceremonies. The daughter used to receive certain property along with the brother. Married daughters received property as a token of respect and love. During Vedic period, the position of women was very much good and respectable. But after post-Vedic era, it witnessed the hierarchical system and social structure was modeled with Brahmanic austerities. During Brahmanic period, four varnas firmly established, and in 1000 BC, Brahmanic period started and remained up to 400 years. During this period, the status of women was being degraded and various social evils has been generated in the society, and that placed the woman under lower condition. This is become indignified period for the women because they are denied education. Pre-poverty marriage was being established. Share in ancestral property was being denied. So these are certain conditions which made the woman in a lower position. So in a medieval period also we will find that Muslim ruled India for about 700 years, during which that Hindu they lost their position. The entire social system has been breakdown and they are being converted, adopted to the Muslim custom, and Hindus are being converted to Islamic faith, and women and the position of the children has been derivated. During this period, social, cultural and religious life of the people are severely degraded. So thereafter we find that Bhakti movement started under the leadership of several saints. The saints like Chaitanya, Nanak, Kabir, Ramdas, Tulsidas, Tukaram, that they have started a religious preaching and they succeeded to provide religious freedom to the women to some extent. But the status of women remain in a lower position still, because the stanza of Tulsidas which provides that Dol, Gawar, Shudra, Pashu, Nari, O Sakal Taran ki Adhikari. You see the position of women during the Bhakti culture. Tulsidas said, drums, rustic, Sudraj, animal, and women all deserve beating. All need to be administered through others. So this statement, it is clear that women are not free from social evils and social vices during that Bhakti movement. But during pre-independence era, we find certain changes that has been brought during the British regime. The pre-independence period was dominated by Britishers. They ruled India for nearly 200 years. During this, the status of women witnessed little change because due to the establishment and doctrine of equality and establishment of the educational policy in India, they tried to abolish all social evils and social custom from the society. There is substantial progress in the field of education, employment, and growth of social and economic political rights. Professor Ram Ahuja, a noted social scientist, taken note of all the hands of affairs during the British regime. And to some extent, he has stated that the important aspect of life brought vast social changes in India, which includes industrialization, that is spread of education, social movement, growth of women organization, weakening of the caste system, and impact of the social legislation. During industrialization, great transformation has been looked, particularly in the economic life of the people. It opened a new vistas for the men as well as women, and most particularly, women got freedom to work, and narrow thoughts spaced away, and a new social order established. During industrialization, the economic condition has been improved in a vast extent, and ultimately, women got freedom both in the home as well as outside of the home. The spread of education ultimately created another environment where women got chance, and Lord Dalhousie declared that no single change in the habit of the people is likely lead to more important and beneficial consequence than the introduction of the education in their family children. So both children and women got an opportunity to have English education. There is a much more impact both in the urban population and to some extent in the rural population. Very less impact was there in the rural population, but much impact was marked in the urban population. The spread of female education brought vast social change. Women and children ultimately got better opportunity. So there is a social movement also we have witnessed during the 19th century that upsurged the several social activists like Raja Rammohn Rai, Mahatma Phule, Justice Ranade, Ishwar Chandra Vidyasagar, and so many others. They have ultimately advocated for emancipation of the women and children. During this period, sati system was being almost abolished, widow remarriage system was being established, women property right was being taken into consideration, and thereafter we find another set of social movement started, another set of activists came into the existence, that activists like Vivekananda, that is Dayananda Saraswati, Animation, Mahatma Gandhi, Lala Lajpat Rai, and others, though aroused new social consciousness among the people in India. Mahatma Gandhi led the movement against the untouchability, and others ultimately acted for the social reforms. So growth of women organization was being found during this time. So many organizations came into the existence, and the women particularly took the leadership to safeguard their own interests, and when they came up from the home, ultimately the status of women also raised to a certain extent. So caste system was being weakened during this time. Leading social organizations like Brahmo Samaj, led by Raja Ram Mohan Rai, Arya Samaj, founded by Dayananda Saraswati, raised the status of the women to some extent. The voices of the caste system was imposed and certain restriction on the social evil was being taken into consideration. So, voice against untouchability. The organization advocate for women cause and concern. They try to provide certain relief to the women victim and work against the social atrocities. So, there is a vast social change due to the social legislation. The efforts have been made by the enlightened social activists and various legislation came into the force for the protection of women and children. Such legislation include Child Marriage Restraint Act, Hindu Women's Property Right Act, and so many others. So, despite the fact the women continue to remain in a low social status, women are victimized and crime against women were in abundance in our country during the British rule. Often, women were being discriminated and they failed to raise their strong voice against the masculine culture of men. So, thereafter we will find the post-independence era. After end of the British rule, we the people of India taken a vow to create an egalitarian society of high order. And we intend to ensure justice, social, economic and political. And we intend to maintain the liberty, equality and fraternity. So there were several provisions in the constitution to protect the interests of the women. Most significantly, the constitution recognized the equal status of women and welfare of the children. A new era was being ushered after the adoption of the constitution. The constitution itself has provided a lot of important provision by protecting the interests of the women and children. Justice Krishna here has cited the story of that whatever the paramount parchment of the constitution may intone, whatever the universal instrument may inscribe, we have 2 miles to go and promises to keep if gender justice is not to be mere dope but sure hope. So Justice Krishna here, he was a very much important leader of the society, you can say, because he was having a vast experience of our social justice, and in such cases he tried to implement the law in the process of the judicial process. So he has said that whatever the paramount parchment of the constitution may intone, whatever the universal instrument may inscribe, we have 2 miles to go. Because by forming the law or adopting the international instrument, we cannot come to bring the position clear. We cannot make the women independent unless we have to proceed miles and miles. Justice not to be mere dope. It should not be a mere hope, but it should be established in a practical field. So, Constitution particularly provides 3 important, as per the Justice Upendra, as per Professor Upendra Bakshi, that he has given a concept that golden triangle, because judiciary has adopted Article 14, 19, 21 as a golden triangle, but Professor Upendra Bakshi is having different concept of golden triangle, that is fundamental right, directive principle of state policy, and that is fundamental duties. So these 3 parts of Indian Constitution, that is having much more importance. So for the right of the women and protecting them against the criminal administration of the justice. The importance of the fundamental right has been discussed by the Supreme Court of India in various cases. There are a category of cases. I quote few words of the Supreme Court, that It has said that these fundamental rights represent the basic value cherished by the people of India of this country since the Vedic times. Sorry. Justice Justice P. N. Bhagavati, while delivering the judgment in the matter on this case, uttered these words that these fundamental rights represent the basic value cherished by the people of this country since Vedic times, and they are calculated to protect the dignity of the individual and create a condition in which every human being can develop his personality to the fullest extent. You see the vision of the Justice P. N. Bhagavati. He intended to give importance to the values that has been cherished by people of India from Vedic times. They are calculated to protect the dignity of the individual and create a condition in which every human being can develop its personality to the fullest extent. We cannot extend our personality, we cannot develop our personality to the fullest extent unless we enjoy fundamental right properly. Thus, Article 14, Article 15, Article 16, Article 19, Article 21 ensure to lead the meaningful life and maintaining the dignity of the individual and most particularly women and children. Right to life is regarded as the most precious among all the human rights, and it protects men, women and children from all drudgery of life. Justice Krishna in the C. Muthama versus Union of India case stated that if a married man has a right, a married woman, other things being equal, stands on no worse footing. This misnogamy posture is a hangover the masculine culture of manacling the weaker sex, forgetting the how our struggle for national freedom was also a battle against women's freedom. Freedom is indivisible, so is the justice. You see the words that has been transcribed by the judges of the Supreme Court. So these two judgments makes me to feel that we have started our journey not now, since our Vedic time. We intend to protect the right of the people in general. Sorry. And most particularly protect the interests of the weaker section. To place women in a weaker position. Why? Because very much very much tolerant to the various capacity in various conditions of our life.
विक्रम दास सर, आपके साउंड नहीं आ रही है, थोड़ा सा चेक
Foreign
कर।
legislation and particularly direct
थोड़ा सा साउंड
I'm audible?
थोड़ा सा साउंड प्रॉब्लम है, बस साउंड प्रॉब्लम है। Did this?
Sir, I'm audible now?
Yes, yes, yes. Yes, sir. Go start.
I'm audible?
Yes, yes, yes.
Routiya ji.
Please continue.
Yes, sir. Yes, sir. ठीक है, बोलिए। Please say, sir.
Okay. So, Article 23 and Article 24 have been incorporated in our constitution to stop trafficking of human being and forced labor. Article 21 ensures that the tender age of the children must be safeguarded. So these are the two provisions which intend to create an environment where women and children should be well protected. Article 39 of the Directive Principle of State Policy that provide the health and strength of the worker, men and women, and the teenage of the children are not abused, and children are not forced to do something that is derivative to their age and strength. Part 4A of the Constitution contains fundamental duties for Indian citizen. Clause E of the Article 51A says it shall be the duty of every citizen of India to promote harmony and to renounce practices derogatory to the dignity of the woman. So the Constitution itself has provided a vast information first, that is protection for women as well as the children. So before turning to the Constitution, we must have some idea that how in the international field that women are being given protection. So it reminds me to see adopted, it was not contain the phrase the equal rights of men and women. So by the time women they have started advocated and started struggling, and ultimately the phrase the equal rights of men and women was being established. So women participated in law strong protest for the exclusion and successfully demanded that right of all human beings is equal irrespective of their gender. Because the UN itself has not adopted the principle of equality for both the sexes. So it is the women they have protested. So it gives me that impetus that women are not weak at any moment. They are very much strong within, but sometimes we see in different way. Because the women remain unequal with the men in most part of the world. If there is no, if there is a sign that if there is no perception, there will be no conception. So most of the women are not aware about their right. Once they will be made aware about their right, ultimately they can come out and take up the matter for their own sovereignty. Justice Krishna once pointed out that the fight is not for women's status, but for the human worth. The claim is not to end the inequality of women, but to restore human justice. The bid is not for loaves and fishes, for the forsaken gender, but for cosmic harmony, which never comes till woman comes. Women's exploitation is a reality, and gender justice is a fragile myth. Women emancipation lies in their education and their awareness. So these are certain important words that ultimately tells us that unless the women will be not educated, unless the awareness is being not created, then definitely that women folk will suffer in our country, not only in our country, throughout the world. So UN Charter and UDHR have adopted certain principle of it is gender equality for women as well as the men. So next, the International Covenant on Civil and Political Rights 1966, International Covenant on Economic and Social Cultural Rights of 1966 also reinforce the concept of equality. Besides these two covenants, specialized agencies like International Labour Organization, United Nations Educational and Scientific and Cultural Organization adopted convention concerning the various issues of women and children. The Convention of Elimination of All Forms of Discrimination against the women is a milestone in the preservation of the dignity of the women. There are so many conventions has been made in the international era, and the preamble of the Convention of United Nations, the Universal Declaration of Human Rights, and the International Covenant on Human Rights and other instruments, the United Nations and specialized agency, despite the progress made on the matter of equality and rights, there continues to exist the considerable discrimination against the women. I intend to say that though several legislation has been made, several declaration has been made, but the discrimination still continues because we have not still perceived the idea why the women, why the men, they are subsisting in our society. In nutshell, I can say these conventions are nothing but mere protest against the masculine culture of high arrogance. The world is not yet at halt. The world society is constant approach to stop exploitation of women. We have adopted so many conventions, but in the international arena also we are finding there is certain discrimination continues. In India as well, women have resisted all types of oppression both in the family as well in the society. So women, they are not given equal freedom, equal status with that of the men. Under Indian law, the concept of equality and non-discrimination received due weightage in the constitution and many other legal documents. So there are so many kinds of legislation has been passed. In the inception, Dr. Priya Madam has stated about all these things. So in coming to our point of law, that crime against women, there are several legislation being there in our country. So we can divide them into two aspects. One is crime under IPC and another crimes under special statutes. So coming first, we can say that in IPC we will find several legislation, several laws have been codified. So one is that is rape and custodial rape. The section 375, 376, 376A, 376AB, 376B, 376C, 376D, DA, DB, and 376E. So these are certain laws which was being made from time to time to protect women from the rape and custodial rape. There are certain other provisions like kidnapping and abduction for different purposes, and there is another law that is importation of girls and minor children for immoral purposes under section 366. So murder for dowry, dowry death, and attempt thereof was being very much rampant in our society. So molestation of the girls, sexual harassment, all these things are there in IPC law. So in this context, I will say that we can see that how that law has been established and how the law has undergone certain change. So the sexual offense related to rape committed on women by men and such kind of offences are taken seriously. The rape constitutes a core element of sexual offense against women. It is considered as a heinous crime and bolt on the society. And we must stand up for it. So it is not only causes of physical violence, but also interference with the chastity of the woman. Supreme Court has given several guidelines and provided these words. It causes psychological harm and pushes the woman to lead a shameful life in the society. So society seldom gives sympathetic look towards victim of the rape. Rather, it forces her to lead a life of humiliation and tormentation. So these words have been said by the courts that victim of rape forced to lead a miserable life. Rape offends both her social esteem and dignity of life. We all have witnessed scenario of Mathura case and scenario of Nirbhaya case in 2012. So we have amended the law on rape and enforced them since 2013. Both substantive and procedural law has been amended to meet the changing consequences of rape. The entire nation felt relaxed when 4 victims of Nirbhaya were being executed to death. Rape is treated as a crime not against women and children, but as an offense against the entire society. It violates the human rights of the victim. So we have seen that how the law has been changed from time to time. Britishers, they have adopted this law in our country, but we have seen that this law could not able to check the system, and ultimately the women and children, they are being worst victim of this provision. So Criminal Law Amendment Act of 1983 came into the force. So in particularly when the aftermath of Tukaram case, that is Tukaram versus the Tukaram versus the state of Maharashtra, that we have seen the renaissance of the society when these two accused were being acquitted. Ultimately the entire society revolted against it, and the policemen in this particular case were acquitted. Ultimately the society ultimately raised their voice against it. The definition of rape was widened and several new sections are being introduced thereafter. So you see, when people revolted, so legislature started to carry out its duty. The legislature itself is not thinking that what should be the prospective legislation on it. So when people revolting with their sentiment and creating a havoc in our society, ultimately legislature trying to make law on that point. So as we have witnessed in that is that 1983, that we have adopted several provision under 375 and 376. A, B, C, D was being adopted. Because prior to that, these provisions are not there. we have seen thereafter, when the persons are being acquitted, thereafter we could able to understand that we are not in the position to wipe out the vices of that is rape. So 376A was being adopted, which punishes sexual intercourse with wife without her consent during the judicial separation. So 376B was being adopted, which punishes sexual intercourse by public servant with women in his custody. Because the custodian itself started to do certain things with the women that ultimately deplete the society, social norms. So thereafter, that other provisions have been there, that is section 376C was being there, which punishes sexual intercourse by superintendent of jail, remand home, inmates of hostel and other institution. So it provides higher punishment to those persons, those are custodial, and a new concept was developed, that is custodial rape. 376D was being added, which punishes for sexual intercourse by any member of the management and staff of the hospital with women in that hospital. So these are certain changes we have witnessed in 1983. Then thereafter we have seen the Criminal Law Amendment Act was there in 2013. What I intend to say that we intend to protect women and children from the vices of the society. And we intend to create an egalitarian society of high order. Dear friends, why we could not able to achieve it? Because the law which was being made in the parliament, while implemented in our society, we find that it is not getting its semblance. So after the case, again, the common sentiment of the nation arose to a new height. We find that while protest forced government to constitute 3-member committee headed by Justice J.S. Verma to recommend changes in the criminal law. Why not before? Because before also we have witnessed several certain things. It was not hurting us. But when common sentiment has been expressed by the people, legislature ultimately become overactive. And the government started to form a committee which will ultimately look into the matter. Justice Verma committee has taken serious look to it, and so many intellectuals have suggested certain means to stop the menace of rape. So it provided for quicker trial and enhanced punishment for criminal accused for committing sexual assault against women and children. It made recommendation on laws relating to rape, sexual harassment, trafficking, child sexual abuse, medical examination of victim, etc. The committee recommended that the gradation of sexual offences should be maintained in IPC. There should be certain gradation. Different person committing the same offense should get different type of punishment. So this gradation system was being adopted, and the Justice Verma Committee viewed that rape and sexual assault are not merely crimes of passion but expression of the power, the masculine power, the power which the men enjoy in the society. They must be ultimately taken to consideration. Rape should be retained as a separate offense and it should not be limited to penetration into the vagina, mouth, and anus. Sexual nature should be included in the definition of rape, that non-consensual penetration should also be punished. Thus, marriage should not be considered as an irrevocable consent to sex acts. Thus, the committee recommended that an exception to the marital rapes should be removed. So, the woman itself, while in the marital bond, feeling very much depression and ultimately violated her right. So, why she should be the victim of it? Therefore, Burma Committee recommended strongly that there should be the provision for the punishment in the case of marital rape. It provided severe punishment for rape offenders, that is life, that is rigorous imprisonment of life, that means remainder of the person's natural life. You see how the things have been changing. I told him something, since the Vedic civilization we are making the progression to give protection to the women and children. But we have not done it. We have not achieved it. Because if good people will remain complacent, bad people will rule over us. So the good people should come out. Good people should exercise their thought. The good people should come out with all strength, and so that bad people will ultimately vanish from our society. So we have raised the punishment to a greater extent. That 376A provides punishment that is rigorous imprisonment up to 20 years or life imprisonment or death. For the first time, death penalty has been imposed for the offense of death. There was much protest against it, but the protest was mingled in the voices of parliament. So, section 376B, which provides sexual intercourse by husband to his wife, living separately and under decree of judicial separation, that when the sexual act has been done by him without her consent, it also provides severe punishment, and that is 2 years to 7 years and with fine. So, coming to section 376C, sexual intercourse by person in authority. The fiduciary relation, public servant, superintendent jail, remand home, place of custody, and staff of hospital and other institution. They must be punished because they have defied the relationship, that is fiduciary relationship. The person who is going to seek protection from whom they are committing rape to the women, they are all children, therefore they are being punished. So 376D that was being adopted, that is gang rape. So it is imposing that a fine should be collected and the fine should be given as a compensation to the victim of rape. So life imprisonment was there, 20 years imprisonment is there, fine was there. So there was another section, that is section 376E, punishment for repeated offenders. So these are the new norms has been adopted in this legislation. So that is imprisonment for life. Life means to the remainder of the life or with death. The repeaters of the crime of rape must meet the death. So this is the feeling and this is the object of the legislature. So thereafter also we find there was a certain amendment in 2015 and 2018 also. After following the outcry of the rape of murder of the minor girl in Kathua in Jammu and Kashmir and the rape of another woman in Unnao in Uttar Pradesh, Lok Sabha passed the Criminal Amendment Act 2018 in July 30. So this amendment amended IPC, CRPC and adopted POCSO Act. So you see that how the legislature it is acting, it is not acting of its own, but it is acting with the sentiment of the public. So both the incident at Kathua as well as Unnao ultimately forced government to adopt certain stringent legislation. So section 376 again it has been amended, and it is providing a new concept and providing a severe punishment for the rapist. So that is rigorous imprisonment of 20 years has been given the offence of the police officer or public servant or member of the armed forces. Similarly, person committing offence of rape or woman under 16 years of age. Age was very much important in this particular context, and it is providing severe punishment, that is 20 years of punishment, rigorous imprisonment, life for the remainder of the that person's natural death, and with fine. So again, there are certain changes in, that is 376 AV, person committing an offence of rape on a woman under 12 years of age. So these offences are made non-bailable, and it is being tried by the court of session. So this legislation, this amendment intend to provide a easy adjudication process, and that quick investigation and quick judgment also. So ultimately, Article 37, Section 376D(a) was being there. That is gang rape on women under 16 years of age. So it is providing imprisonment for life till natural death or with fine. So it is also tried by court of session, and the offence is that is non-bailable. Then article, that is Section 376DV, that is gang rape on women under 12 years of age. So it came into force in that is 21st April 2018. So it provides completion of trial within 2 months, and it provides disposal of case of rape within 6 months. So there is no provision for anticipatory bail for person accused of rape and gang rape of the girl under 16 years of age. So judiciary has also taken very serious note of the pathetic condition of rape victims. So we have seen in different judgment, in a category of cases, the Supreme Court has reacted and ultimately provided severe punishment and stringent action against the rape victim, the rapist, and the victim are being given adequate compensation and provided social justice. So in Delhi Domestic Working Women's Forum versus Union of India case, it was observed that the investigating agency as well as the subordinate court adopt indifferent attitude towards prosecutors. So it is a court itself observed this, that the agency, those are taking the matter into consideration, they are very much indifferent in their attitude. So similarly, the courts are also not showing its that is vigilant attitude. So they are also showing indifferent attitude. The apex court directed to provide assistance to the rape victim. It was issued a detailed guidelines for legal assistance, and in all rape trial, that is anonymity of the victim must be maintained. As far as necessary, victim of rape shall be awarded compensation by court, and the court shall adjust suffering, pain, shock, loss, or earning due to the pregnancy, expenses of childbirth, etc. Home Ministry was being directed to give effect to such guidelines. So this particular judgment has given a very much stringent verdict, and it is providing that the Home Ministry should make certain condition, so that every person in the hands of the administration of criminal justice must be aware that they should provide protection to the rape victims. They should be given legal aid, they should be provided legal assistance, and they should be also paid compensation. Then medical witness, the medical examination must be there. So these are being guided by the court itself. So in Shankar Kishan Rao Khade versus State of Maharashtra, Supreme Court issued another guideline to prevent child sexual abuse, because children are always victimized both in the family as well as outside of the family. The person who is supposed to take care of the children, they are ultimately causing victim of the child. So that welfare committee, NGOs, women organizations may take further follow-up action in consultation with the Juvenile Justice Board and local police authority. Particularly, a separate unit of the juvenile police unit was being adopted under Child Care and Protection Act. So many important execution was being there, but we find that always women and children are being victimized. So section 304B was being adopted to stop the dowry death. The menace of dowry death was being abandoned in our society. That dowry death and cruelty was being inserted in IPC, which came into force with effect from, that is, 19 November 1986. The provision was inserted for combating the menace of dowry death. As per the provision, if death of woman caused by burns, bodily injury, or it occurred within 7 years of marriage, soon before her death, she was being subject to cruelty and harassment by the husband or relative of the husband, and it is done in connection with the demand of dowry. So this provision is creating an atmosphere that there will be presumption against the culprit, that if the death occurred within 7 years of marriage, then it will be deemed, it will be presumed that the death has been caused due to the demand of the dowry. And all the persons those are being involved in this act must be stringently provided punishment, and that is 7 years imprisonment was being provided and extended to imprisonment for life. So this law itself was there to protect the woman from the clutches of the drudgery social condition. Section 312 and 313 also providing, that is punishment for the miscarriage. So the child who is supposed to get asylum in the mother's womb are being miscarried either by the woman herself or at the instance of her family members. So it prescribes punishment for causing miscarriage without consent of the woman. And section 313 provides punishment with life imprisonment and 10 years, that is imprisonment or with fine. The Medical Termination of Pregnancy Act 1971 provides for the termination of pregnancy by registered medical professional to save the life of the mother and future of the child. The Act never authorizes husband to go for abortion. Thus, any person abetting the offense is made liable. So, these provisions are there to protect the interests of the children as well as the women, but the law could not able to implement in 100%. So, Section 354, which deals with the outraging the modesty of the woman. So, it deals with the assault of criminal force. If it is used to any woman with intention to outrage the modesty of woman, then in such cases the punishment is being provided that 5 years punishment, 1 to 5 years punishment is there and shall be liable to fine. Higher punishment was inserted in Criminal Amendment Act of 2013 because the things are going in an abrupt way and ultimately the women are not getting justice in our society. So another provision is there in IPC, that is 354A, that is sexual harassment was inserted by Criminal Law Amendment Act 2013. It provides that a woman shall be liable for causing physical contact, making sexual overtures and demanding for sexual favors, showing pornography against the will of women and making sexually colored remarks shall be guilty of sexual harassment. So a new provision was being adopted. Then section 354B was being provided, prescribing punishment for the use of criminal force to a woman with intent to disrobe her. So section 354C was there that punishes men who watches or captures the image of woman engaging in the private acts and is prescribed the offense called voyeurism. A new kind of offense was being there. When a woman is maintaining her privacy, doing something by secret, if somebody is following her, then in such cases, the section provides punishment for it. Then section 3, that is 354D was being there. If any man follows a woman and contact such women to foster personal interaction shall be punished for this offense. This is called stalking. So these are the new kind of offenses that has been adopted in our IPC. So there is 3 years punishment and fine was being given in case if it is repeated, then the offence is providing higher punishment of 5 years as well as the fine. In this context, the Supreme Court passed a verdict and protected the dignity of the woman. It's known as the Visakha guidelines. We all are knowing that how Visakha guidelines was being there and which providing that how the woman will be given safe in the workplace. It was directed to state government to take necessary steps to protect women for the purpose and if teaching and must be stopped. And in such cases, it is directed to install CCTV strategy, and it was directed to establish women helpline and to stop menace of teaching. District collector, district superintendent of police are also given direction to take effective measures to curb the menace of this type of crime. So IPC section 360 for kidnapping and abduction. So that when a person is being kidnapped from the lawful guardianship, ultimately that person will be punished. To protect the children, that the guardianship is being well protected. Then section 363 prescribes punishment for kidnapping and maintaining maiming of minor child for purpose of begging. So in our society, some cruel persons are there. They are cutting the hands, cutting the legs, or they are mutilating the body of the children, and they are making them to beg in the society. So begging on that context is causing a serious concern for the protection of the children, and it provided punishment that is 10 years and fine. So section 364A was there, that is prescribing punishment for that is punishment for ransom. So persons minting money out of this. So when children are being taken away from the guardian, and ultimately they are claiming that if this you want your child, then you have to pay me this much amount. So to stop that kind of crime, this section 364A was being adopted. So section 366 prescribes punishment for kidnapping and abduction of women to compel her to marriage. So some children are being taken away from the lawful guardianship and they are being forced to have their marriage. So section 366A was there that prescribed punishment for procuration of minor girl for illicit intercourse. So if any children has been taken away for immoral purposes, this section provides punishment that is 10 years imprisonment as well as the fine. Section 369 providing punishment for kidnapping or abducting of the child under 10 years with intention of taking dishonestly. So in such cases also punishment provided in IPC. Section 370 punishes for the trafficking of person. So particularly in Article 23 we have said that trafficking of human being is prohibited, and IPC also provides that punishment if any person is being trafficked. If buying and selling of the girl was being done for the immoral purposes, section 370 providing punishment that is 7 years punishment as well as the fine. Section 393 of IPC prescribes punishment for cohabitation caused by men deceitfully inducing a belief that lawful marriage. We have seen so many cases. We have seen the case of Subhra Chakraborty and Bodhisattva Gautam. So many other cases are there. In our society, some people are very much innocent and some persons are very much cruel in their attitude. So that cohabitation is being caused by deceitful means, giving a belief that you are my married wife, I am lawfully married, therefore you extend sexual activities. And in such cases, it is prescribing punishment that is 10 years imprisonment as well as the fine. So section 394 that is punishing for that is bigamy. We have seen that there are several cases have been made by several cases are there in the Supreme Court, and Supreme Court has directed that we must have a uniform civil code. Till now, we have not adopted that. We are not thinking so far that bigamy should be there in our society. All form of customs, all such tradition should be stopped and should not go for the position of bigamy. So, if any person during the sustenance of the spouse contracting second marriage, then in such cases that will be punishable under section 394. Then in such cases 7 years imprisonment and fine is being provided. Then section 395 prescribing punishment for concealing the fact of the previous marriage. Sometimes some person they are duping the woman, saying that I am not married, but in fact they are wives. And in such cases, they are being punished under section 395. 10 years punishment is there and fine is also there. Section 396 providing marriage ceremony undergone fraudulently without marriage. Fraudulently, if there somebody is cheating and causing marriage and ultimately cohabiting, in such cases, 396 is providing punishment for it. Section 397 providing punishment for adultery. And at this moment, you know the changes have been made in the adultery law. Then 498A is there. 498 is there. 498 provide punishment for taking or enticing a woman with modified intention to illicit intercourse of married women. Sometimes in our society, married women are being enticed away by some other persons. In such cases, they are being provided punishment for it. So 498A was being added to stop cruelty by the husband. It prescribes punishment for subjugating her to cruelty. The cruelty is having a wider definition in this context, and women, those are being subjected to cruelty by the husband or the relative, they are being punished severely under this section. That is 3 years punishment is there and fine is also there. But at this moment, Supreme Court has also provided some guidelines on it. Because sometimes some ladies there ultimately give their husband and their relatives. So many, that is false allegation has been made by the women and they are punishing otherwise. So there is a certain change in this law also. So section 309 providing that if any person intended to insult the modesty of women and pronounces any words, making any gesture or exhibit any object that intrude her privacy, in such cases it provides punishment for it. So there are so many legislation that particularly in IPC law, particularly in IPC we find several sections that is protecting the women and children. So thereafter you will find that in criminal procedure law also that particularly section 125 providing maintenance to the children, women and the parents. So in such cases, all women as well as the children are being protected, that when they are having no subsistence, they are having no sufficient subsistence for living. In such cases, it providing responsibility that the person who is care of the person must provide protection, and that interim maintenance should be provided to the dependent, particularly wife, mother, children, and divorced women and widowed daughter-in-law. So these are certain provisions providing certain safeguards to the women and particularly women and children. So as I have already told you that I will divide into two parts. One is IPC law and another is other special law. There are several special law. Priya Madam has also stated about some special law. But it is very much difficult to tell all kind of special law that has been made for the protection of the women and children. So particularly there are legislation which is protecting the women and children from the vices of their criminality, that is Dowry Prohibition Act of 1961. As already these provisions are there in IPC, still to make it very much stringent, a special law has been brought by the legislature, that is Dowry Prohibition Act of 1961. It is meticulously defined what is dowry and what should be the penal provision for it. So it is a special legislation which takes care of the that take care of the victim. Those are victim of the dowry. This legislation was being passed, but it is provided that it takes care to exclude presentation in the form of clothes and ornaments that has been given to her as a matter of love and affection. The limit has been fixed by the legislature that will very much surprised to know that only 2,000 rupees was being provided, that this should be the limit of the presentation. Then Section 4 of Dowry Prohibition Act provides punishment if anybody offers bribe or takes the bribe. So it provides punishment that is 6 months to 2 years for imprisonment and 10,000 rupees as a fine. So burden of proof lies on the husband and their relatives. So this is another law which is protecting the interest of the woman. So there are other laws, that is Immoral Traffic of Prevention Act of 1956. The object of the act is to prevent and suppress the immoral trafficking in women as well as in children. As already I have stated that in IPC the same provision is there, in Constitution the same provision is there, still we have made a special law. The object is that anybody is keeping brothel or anybody is having any institution which practices prostitution, this should be punished. And it is providing that severe punishment, and it is also providing very special provision for spirit trial. Coming to the next law, that is Commission of Sati, that is Prevention Act of 1987. It reminds us the story of Rup Kanwar of Rajasthan. Deorala village was being famous in our state, in our country, because that is Rup Kanwar, an 18 years of lady, subjected her, forced her to die in the palace of her husband. Again, the public sentiment was being raised, and ultimately the person was being, we couldn't able to protect her, and she was being died under this condition. So a law was being made that glorification of sati is being prohibited. Any person abetting it, any person putting a part of it, then they will be liable under this law. Then coming to the next law, that is Prohibition of Child Marriage Restraint Act and the Child Marriage Prohibition Act of 2006. Both the law was there, and previously that Child Marriage Restraint was repealed by adoption of Prohibition of Child Marriage Act 2006. Section 9 provides that if a male or adult above 18 years contracts child marriage, shall be punished with rigorous imprisonment of 2 years or with fine of 1 lakh rupees. So Section 10 also provides that if any person performs conducts abets child marriage, shall be punished with rigorous imprisonment of 2 years and a fine of 1 lakh rupees. Section 16 empowers child marriage prohibition officer to prevent solemnization of child marriage. So these provisions are there. National Plan of Action for Children 2005 had set a goal that within 2010 we will eliminate all sorts of child marriage. But it is unfortunate to note that there are so many cases still they are witness that there are child marriage subsist. Then another law is there, Indecent Representation of Women Prohibition Act 1986. Though we have law that is Section 292, 293, 294 of IPC to stop the vulgarity and obscenity. But looking to the growing situation of the country, that indecent representation of women and a reference of women in the publication of particularly making advertisement, this law was being passed. Because we are, in all contexts, we are using women as a man of advertisement without looking to her decency and obscenity was being tried to be identified. And in such cases, that nothing derogatory to the woman and any kind of practice that is ultimately taking away the privacy of the woman is being protected. Section 3 and 4 prohibits advertisement, production, selling, letting to hire, distribution, circulation, and sending of post, book, pamphlet, paper, slide, film, writing, drawing, painting, photograph, representation, and other figures which contain indecent representation of women. So coming to the next law, that is Information of Technology Act 2000. So there are so many other legislations. So all legislation intend to take care of the women as well as children. But unfortunately that we have not made conscious till now, and the things are going in different way. Because section 66 prohibits publication of any material which is lascivious and
सर साउंड प्रॉब्लम आ गई है। विक्रम सर, हेलो विक्रम सर, विक्रम सर,
some problem was there, that's why the sound was not there. I am now audible.
नो सर,
Routed.
नो नो नो,
So
आप दिखाई नहीं दे रहे हैं, यू आर नॉट वाचिंग। हेलो सर, क्वेश्चन आवर कर चालू कर दे क्या? क्वेश्चन आवर आपका
I am audible.
नो सर,
I am not audible.
नो सर,
Sir, you are audible, but you are not visible. You are audible.
Okay. So I have some problem with my computer. So
राम मैम क्वेश्चन पूछ दीजिए, क्वेश्चन आवर चालू कर दीजिए।
Sir, best solution is please leave the meeting and join again. That will be better, sir.
Sir?
Sir, you may leave the meeting and please join again.
Okay. Sir, I am audible now.
Yes, sir, you are audible.
So please wait, because that battery has been exhausted from my laptop. That's why I am not visible, sir.
Oh, okay, sir.
मैडम, राव मैडम, आप एक दो क्वेश्चन है, क्वेश्चन पूछ दीजिए। राव मैम,
जी सर।
एक दो क्वेश्चन पूछे हैं बच्चे जो हैं, उनको क्वेश्चन को पूछ दीजिए, सर जो है रिप्लाई दे देंगे ऑडियो में जी, ऑडियो में ही रिप्लाई दे देंगे वो।
Sir, can you hear me?
Yes.
Yes,
ma'am.
There is a question from Ishita Johnson. She is asking that even if there are so many laws and acts passed by the government of India and judgments made, why is there still a threat to women and children of India?
Nice question, madam. Ishita, you say that already I have stated in my discourse that we have so many legislation, but how much we are aware? We are not aware about it. So I will just have a very simple thing, that unless good people are not coming up, then bad people are reign over good people. So here I intend to say that when legislations are being passed in the parliament, so it is being remain in the cold storage. Who will ultimately give success to the people? People are not getting proper justice because they are not aware about it. That already I have stated that in UN, that equal status was not to the women, but in UN, the women protested very vehemently. So in UN charter, the matter was being taken into consideration, and equal justice system was being adopted in the UN General Assembly. So similarly, in our society, we have to create certain organization. I have stated you about the history of India. During Vedic civilization, during Bhakti movement, thereafter social organizations came out, and ultimately they have adopted the principle in our society. So we have to create our own society where women can be protected, children can be protected. I'm sure that you will happy with my answer.
The student further asked, does that mean that we are not following the rules and regulations given to us by the government, or is it that we are afraid? We aren't afraid of it, or is it that people aren't afraid because even after such rigorous punishments, there are loopholes present in the laws which enable the wrongdoer to escape from it?
Madam, kindly repeat the question.
Yes, sir, yes. So she has asked, does that mean that we are following the rules and regulations given to us by the government and we aren't afraid of it? Or is it that people aren't afraid because even after such rigorous punishments, there are loopholes present in the law which enables the wrongdoer to escape from it?
Okay, madam. There is no question of afraid. But first of all, if you are not aware, then how can you enforce it? Suppose the enforcing agencies are there, they are very much complacent in their duty. You are unable to enforce the law because the alternative is there. Law provides the alternative. Suppose you are making a FIR, police is not listening to you. You have remedy. You can go to the court of law. You can go to the magistrate. But this thing is not known to anybody. Suppose you are not wearing helmet. Police is asking that you pay 2,000 rupees, and people are paying 2,000. Sometimes they are paying 500, and that they are also providing bribes to the people. So this is happening because the people are not aware about it. Therefore, I said, if you do not have any perception, you cannot have conception. So if you have conceived the idea, then definitely you try to find the way, find the means how it to be implemented. So implementing agencies are there. We have to knock the right door. So if you are not knowing the law provision, if you are not knowing the enforcement agencies, if you are not knowing that how it to be implemented. So thereafter also the fear psychosis generated. So we are afraid of that it will go to the, it will take a long time, it will be not a course. So very much that is complacent, and we are not enforcing the legislation.
Thank you.
Another question is, Varanya has asked that when more than one person is involved to kill other person with same intention, what is the provision?
I couldn't got the question, madam.
Sir, when one or more persons are involved.
Your voice is not clear, madam.
Voice, yes, sir. And how is it audible? Can you hear me, sir?
Audible.
Yes, sir. When one or more persons are involved in killing a single person, then what is the provision in law about the common intelligence?
What is that?
Common intelligence. Section 34 when more than one person with the same intention.
When more than one person involved to kill a person with same intention.
Sir, when there is one or more person involved to kill one person, then what are the remedies of consist? Oh, so when one or more person involved in the killing a person, what should be the remedy? What should be the remedy? You see, at this moment, the psychology of the people. A person is killing somebody, and a cameraman is making the photograph and ultimately publishing it. If he could have involved there, definitely the crime wouldn't have committed. Because the people must be very much active. The organization should be very much active. Unless with the people all together combinedly not fighting out the crime, then crime cannot be omitted from our society. So it requires a joint effort. Every time we must act against the crime, because crime is not against an individual, crime is always against the society.
Okay. Summarize कर दीजिए
Thank
मैडम.
you so much, sir. Thank you so much, sir, for your valuable information and speech delivered today. Discussed about Justice P.N. Bhagwati Mehta Rani case.
Yes, sir.
Ji, sir. Should I continue?
Yes.
Yes, madam.
Sir, you discussed at length today about the constitutional provisions in law about women and children, and you elaborately discussed about the international covenants, UN Charter, UDHR, which has adopted regarding the gender equality. And so you have very nicely explained us about the international covenants of social and political rights, the CEDAW Convention on Elimination of any form of discrimination against women. And we are very happy that you made us very clear and students about the provisions in IPC regarding women and children. And you also discussed about the special laws which are specifically made for children regarding POCSO, juvenile justice, and so many laws which you discussed today. I am sure that my students and all the participants of this workshop will be highly beneficial after listening to your speech, sir. And I am very thankful on behalf of School of Studies in Law. And I personally thank you, sir, for coming here on our invitation and gracing this occasion and sparing your valuable time with us. Thank you so much, sir. May I call upon
I extend my heartfelt thanks to you, all the organizers, for giving me an opportunity to speak few things on this occasion. Particularly, I extend my heartfelt thanks to Priya Ma'am and Routiya ji, and particularly the patron who has given me such opportunity to speak before you. I am very much thankful to all the participants that you have given me a thing, and I anticipate that if you have listened, you must play very much active role, so that all the activities which I have done, what the organization intended to tell, it will be objectified. Thank you very much. Particularly, I extend my heartfelt thanks to Chaudhary sir, because he has also given opportunity to speak few words before you. Thank you very much to all for giving me the grand opportunity. Thank you all.
Dr. Raju Chaudhary sir, explain it.
Thank you, sir. Sir, from each and every unit associated with this organization, I express my sincere thanks as a head officially. And sir, in future also we are looking for your continued cooperation. We will take your services in future too. Thank you, sir.
स्टूडेंट्स, मैं आप लोगों को कल का प्रोग्राम बता देता हूं कि 17 सितंबर डॉक्टर विजयनंद बेहरा सर का क्लास है. बहुत ही अच्छा क्लास है. हेल्थ, हाइजीनिक, कोविड-19, रोल एंड रेस्पॉन्सिबिलिटी ऑफ द सिविल सोसाइटी. ये टॉपिक जो है इसलिए रखा गया है क्योंकि अभी कोविड चल रहा है, और साथ ही साथ ऐसे स्थिति में पुलिस का रोल, हेल्थ ऑर्गेनाइजर का रोल, साथ ही साथ सिविल सोसाइटी का क्या क्या रोल है, इसके बारे में विस्तार से जानकारी देंगे. कल के प्रोग्राम में 12 बजे प्रोग्राम होगा, और डॉक्टर विजयनंद बेहरा एलआर लॉ कॉलेज के प्रिंसिपल हैं, और इनका जो सब्जेक्ट है, उनके अनुभव के आधार पर ही हम लोग जो है पूरा इसका लाभ लेंगे. मुझे पूरा विश्वास है कि आप लोग भी जो है कल सारे पार्टिसिपेट करेंगे. साथ ही साथ ये जो लेक्चर सीरीज है ये 18 सितंबर तक चलेगा, और लास्ट जो सीरीज है 18th का जो है वो भी मोस्ट इम्पॉर्टेंट है. यहाँ पर आपको बता दें कि डॉक्टर सुरेंद्र कुमार जी का लेक्चर होगा, राइट टू लाइफ एंड पुलिस एनकाउंटर. बहुत ही मजेदार टॉपिक है, कल और परसों दोनों दिन का. तो मैं आप सभी से अनुग्रह कर रहा हूं कि कल के प्रोग्राम और जो 18 का जो प्रोग्राम है उसमें भी पार्टिसिपेट जरूर कीजिएगा। थैंक यू। थैंक यू सर।
Thank you.
Okay.